So guys, today I will be making a playlist of videos on the subject private international law. And before jumping into the video, I would kindly request the students to have a note and a pen or a pencil to jot down the notes as I instruct them. And also watch this video in 1.5x speed. Thank you. So in today's video, that is part 1 definition video, we will be seeing the definition of private international law. So there are mainly three important definitions given by three people for private international law. I mean four people. So one is a collective definition by Cheshire, North and Fawcett. The other two definitions are by Batty and Cheshire. Okay. First we need to understand why these people's definitions are very important. Okay. Who are these three people? Who are these four people? These people are from United Kingdom. They are British people. Okay. They are Brits, and they were practicing professions of lawyers, legal scholars, and authors of various books in the context of private international law. And how does it make them eligible to give definitions for private international law? Because at the time they were doing it, they made significant contributions. They made significant contributions for the private international law, such that even today the students and legal scholars are researching their work. Okay. Having been said that, let's jump into the first definition. First definition is given by Cheshire. He says private international law. Private international law is that part of law. What is it? It is that part of law. That part of law means municipal law. Or remember the word lex fori, which we will be using in the further videos a lot. Lex fori means law of the land. Law of the land. Or municipal law. Or local law. So what do these terms mean? I'll try to make you understand with a simple example. If suppose, for example, there is an Indian. For an Indian, what is his lex fori or municipal law or local law is the Indian law. Okay. Every other law is his foreign law. Understood? Okay. So private international law is that part of law which comes into play when the issue before the court affects some fact, event or transaction. So there is an issue in the hand of the court, and some facts of the issue or some events or transaction in the issue is closely connected with what? With a foreign system of law. With a foreign system of law. As to necessitate recourse to that system. So it makes it necessity for going into the foreign law to administer justice. To administer what? To administer justice to the issue or the case. That is the main thing, main principle behind private international law, to administer justice. So justice system itself is to administer justice. The private international law is no exception to it. So the purpose of private international law is also to administer justice. So I will try to make you understand with another example so that it is very clear for you what I am trying to convey. Suppose, for example, there is a car accident. Okay, there is a car accident that is happened in London. I'll write those things with blue color places so that it is a car accident that is happening in London. So both driver for D and victim for V, both these people are from UK. They are Brit people, which means they are London or some other city in there. Okay. Here the issue here is the driver's insurer. Who is it? The driver's insurer is an American. Okay. Driver's issuer is an American. So what happened is the suit was filed in an American court. American court. So what will the American court do now? So the American court used the British tort laws. The American court used British tort laws and case laws. To administer justice. To do what? To administer justice to the case. So in this case, if you see, the issue before the American court had some connection to the foreign system of law. Issue before the court had some connection with the foreign system of law, that is the British law, because the accident had happened in London and both the driver and victim belonged to London. But since the driver's insurer was an American, the court case was filed in an American court. And given that if the American court had used American laws to deal with this case, then what would have happened? There will be difference of laws in both America and Britain. And what will happen is that there will be no proper administration of justice, because there is going to be a difference of traffic laws in both these countries. And when that happens, there will not be a proper justice given to the victims. So the American court, for the American court, it became necessary, as the definition says, necessitate recourse to that system. It became necessary for the American court to use the British tort law and case laws to give justice in this case. So moving on to the next case, next definition is given by Batty. And what this person is saying that the private international law is nothing but the rules voluntarily chosen by a given state for the decision of cases which have a foreign complexion. So private international law is nothing but rules that are acknowledged by states, for deciding their cases, for decision of cases that has a foreign complexion. When there is a foreign complexion means some difficulty arise due to a foreign element, then for deciding such cases, private international law will be used. That is, some rules will be used. That rules are known as private international law. That is what Batty is trying to say. So next definition is given collectively by Cheshire North and Fawcett. So private international law is that part of English law. Okay, that part of English law which comes into operation whenever the court is faced with a claim that contains a foreign element. So they are giving their version of the English version of private international law. What is a private international law in English law? That is what they are trying to say. So here they are using the word foreign element, and in the previous definition Batty says foreign complexion. Both are more or less similar. When he is saying that when there is a problem arises due to foreign element, the rules will be invoked. That is, those rules are known as private international law. Here Cheshire North and Fawcett collectively they are saying that if a foreign element itself is involved, then the claim faced by the court will use a private international law for solving that claim. That is what they are saying. With this, I am concluding the first part. Please stay connected with me for the second part and so on. Thank you.